Further submissions by defendant with proposed defense. Exhibits in support of defendant's testimony. Date 29 November 2023. To the Registrar of the Manukau District Court. And to the New Zealand Police. May it please the Court. The defendant further submits the following: 1. The defendant, Tony Raymond Adams, submits the following additional information, concerns and exhibits Mr. Adams wishes to rely upon and submit in support of his testimony, to be given on 5 December 2023 at Manukau District Court. 2. As a self-litigant, Mr. Adams is uncertain as to when to submit these enclosed exhibits, and will also have these exhibits to enter during his testimony should that be the correct procedure. Discriminatory and intimidating behavior. 3. At the commencement of the defendant hearing presided over by Judge J.H. Lovell Smith on 22 September 2023, the court was very clear to Mr. Adams' Mackenzie friend Mr. Keene, regarding the prohibition on the use of cell phones and recording devices in court. As Mr. Keene respects the court's wishes regarding this prohibition were accepted and obliged with. 4. Prior to the commencement of the defendant hearing on 21 November 2023, while sitting in the public gallery, Mr. Adams and Mr. Keene witnessed a court security officer request that a member of the public sitting in the public gallery, who was using her cell phone, to switch it off, which she obliged. Noticing this, Mr. Keene quietly and respectfully asked the court security officer that if no cell phones are permitted to be used while court is sitting, how is it that, at that time, 3 lawyers sitting at the tables along with 2 police officers sitting in the public gallery were allowed to be using their cell phones? 5. The court's security stated that the lawyers were permitted, and that the police officers were officers in charge and also permitted. This was accepted by Mr. Adams and Mr. Keene. 6. At the commencement of the defendant hearing presided over by Judge J.H. Lovell Smith on 21 November 2023, the court began by explaining why lawyers were allowed to use their cell phones in court, clearly showing that the court security officer had brought Mr. Keene's question regarding this issue to the court's attention prior to the hearing beginning. After the court finished explaining, the court then directed that both Mr. Adams and Mr. Keene were to surrender their cell phones at the security desk before the hearing was to proceed, and briefly adjourned for Mr. Adams and Mr. Keene to comply with this direction. 7. Both Mr. Adams and Mr. Keene were left feeling discriminated against, as Judge J.H. Lovell Smith clearly had no issue with Mr. Adams and Mr. Keene retaining their cell phones during the September hearing, yet required the defendant and Mackenzie friend to surrender their cell phones before the beginning of the November hearing. This appeared solely due to a question being asked of the court's security, and left an impression of bias being displayed by the court, due to this direction being made without any demonstrable justification for such a direction. See Guidelines for Judicial Conduct 2019, Section E. 8. Furthermore, at the commencement of the defendant hearing, given courtroom 3 was of a layout more of a family court setting, several stacks of blank forms were left on the tables. Judge J.H. Lovell Smith directed that these forms be moved to allow more space for the defense. In an attempt to be helpful, Mr. Keene started to collect the forms, to hand to the registrar. In response, Judge J.H. Lovell Smith abruptly instructed Mr. Keene not to assist. Mr. Keene found this behavior, tone and manner of Judge J.H. Lovell Smith very undignified and disrespectfully directed at himself, and requests that the court please refrain from such behavior again, as this was distressing at the time, and only asks that the respect and dignity Mr. Keene has for the court and judiciary be reciprocated. See Guidelines for Judicial Conduct 2019, Section F 29-35. Hearsay testimony. 9. During the hearing of 21 November 2023, while testifying, Senior Constable Sherry Hare, in response to being asked if her use of force against Mr. Adams at the time was reasonable or justified, SC Sherry Hare referred to a video she had viewed several days after the alleged incident, stating that after seeing Mr. Adams' interaction on the video with Blinky Bill that yes, her actions were reasonable and justified. Mr. Adams wishes to bring to the court's attention that as SC Sherry Hare had only attended Auckland Airport on the day after this interaction between Mr. Adams and Blinky Bill, and had no first-hand primary knowledge of this interaction. SC Sherry Hare's knowledge gained from the video, post 16 July 2022, is hearsay and as such is inadmissible. Mens Re. 10. The prosecution has not to date pursued mens re, therefore have been unable to establish beyond a reasonable doubt that Mr. Adams had any intent to commit any of the alleged offenses before this court. Exhibits, Relevant Law and Administrative Law. 11. Exhibit D1 is Section 14 of the New Zealand Bill of Rights Act 1990, which affirms Mr. Adams the freedom and right to seek, receive and impart information and opinions of any kind in any form, including however not limited to, using his cell phone in a public place, such as Auckland Airport, to document the poor behavior and service displayed by Jetstar management on 16 July 2022, and for his protection, when approached by NZ Police. 12. Exhibit D2 is Section 5 of the New Zealand Bill of Rights Act 1990, showing that any limitation to rights affirmed within BORA must be demonstrably justified. No such limitation has been demonstrated, and of note, no evidence of any prohibition on recording has been produced by any witness or the prosecution, and no signage prohibiting recording at Auckland Airport are posted. 13. Exhibit D3 is page 8 of 49 from 10.1 New Zealand Police Intranet, released under the Official Information Act 1982, NZ Police Instructions on Behaviour Offences, specifically defining that a public place includes any airport within the meaning of Section 2 of the Airport Authorities Act 1966, which Constable Aaron Schuster read during his testimony on 21 November 2023. However, he stated that this depended on what Section 2 of the Airport Authorities Act 1966 defined an airport as. 14. Exhibit D4 is Section 2 of the Airport Authorities Act 1966, showing the definition of airport, and confirming that Auckland Airport is indeed an airport and therefore a public place. 15. Exhibit D5 is Section 2 of the Summary Offences Act 1981, interpreting a public place as meaning a place that, at any material time, is open to or is being used by the public, whether free or on payment of charge. Further confirming that, as Auckland Airport was open to the public on 16 July 2022, it was, and is, a public place, regardless of it being private property or not. 16. Exhibit D6 is Section 2 of the Crimes Act 1961, showing the interpretation of assault, given that during Constable Aaron Schuster's testimony, he was uncertain what assault meant. Therefore, to assist in clarifying what assault means, Mr. Adams submits that assault means the act of intentionally applying, or attempting to apply force to the person of another, directly or indirectly, or threatening by any act or gesture to apply such force to the person of another, if the person making the threat has, or causes, the other to believe on reasonable grounds, that he or she has, present ability to effect his or her purpose, and to assault has a corresponding meaning. Mr. Adams submits that SC Sherry Hare testified to both threatening to use force, and without reasonable grounds used force, to make or effect Mr. Adams' purpose, and prevent Mr. Adams in the exercising of his rights at the time of the incident, as shown on the video evidence, without any justifiable limitation, namely to stop him recording and documenting the incident and interactions. 17. Exhibit D7 is Section 4 of the Policing Regulations 2008, showing the information that evidence of identity and authority must bear and state. Given SC Sherry Hare prevented Mr. Adams from documenting her identity, and failed to identify herself upon request. This behavior by SC Sherry Hare, due to either a delusion or misinformed expectation of privacy or prohibition on recording at Auckland Airport, appeared irrational and unreasonable, and did not instill Mr. Adams with any trust or confidence personally in her training, knowledge or abilities. If Auckland Airport was, as she believed, a private place or private property, how can Mr. Adams even be charged with disorderly behavior, as an element of this offense is that the offense allegedly occur in public or within a public place? 18. Exhibit D8 is Section 48 of the Crimes Act 1961, which Mr. Adams submits as a response to the allegation of resisting police, as Mr. Adams was unjustifiably assaulted several times by SC Sherry Hare. He believed he was justified in using, in the defense of himself, such force as, in the circumstances, as he believed was reasonable to use. 19. Exhibit D9 is page 14 of 49 from 10.1 New Zealand Police Intranet, released under the Official Information Act 1982, NZ Police Instructions on Behavior Offences, specifically defining disorderly behavior as being behavior that is seriously disruptive of public order. It must cause a disturbance to public good order, which in particular circumstances of time and place, any affected members of the public could not reasonably be expected to endure because of its intensity and/or its duration, and cites Brooker v. Police 2007 and ZSC 30. Mr. Adams submits that his behavior at that time did not constitute disorderly behavior. Mr. Adams did not raise his voice, or act disorderly in any way. Any escalation of the events on that day were created by the behavior and actions of SC Sherry Hare at that time, as her sole issue during the entire interaction appeared to be that Mr. Adams was recording, which was perfectly lawful activity. 20. Mr. Adams submits that had SC Sherry Hare not escalated the matter by making threats, and then using force against him in an attempt to make him comply with a request that he was not lawfully obligated to follow, the incident would not have escalated further. Mr. Adams' sole intention was to arrange an available flight to Queenstown and leave, if he had not been told by the Jetstar manager to arrange a flight crew. He would not have, if he had not been assaulted by police for exercising his right to record in public. He would not have had to use self-defense against such. 21. Mr. Adams regrets the events of 16 July 2022 that happened, and acknowledges that he could have handled the situation better in hindsight, however maintains his innocence against these alleged offenses before the court.